Hello, I'm Robin Henry. I'm the head of dispute resolution at Collier Bristow, and I have with me senior associate Nichola. And we're here today to talk about litigation and try and answer some of the most important questions that clients have for us in relation to that, and to talk about how to manage the risks that it entails. So I'm going to mention a few general considerations first, and then I'm going to pass over to Nichola, who's going to talk about specific things about timelines and settlement. So 3 questions that clients will always ask us about litigation is: how long is it going to take? How much is it going to cost? And what is the outcome going to be? And they're all perfectly sensible questions, but they're very difficult to answer. And I think there is a wider question that you should be thinking of, and that is how to deal with the risks of a dispute situation generally. Because from where I am, I see us as being in the risk management business. We have a role to play in managing your risks when it comes to litigation. And that's because litigation is unavoidably risky. Everything about it is risky. The actions of your opponents and the courts are risky. The law itself is often uncertain. How witnesses are going to come across is uncertain, and what facts are going to crop up are also uncertain. And that means how much it's all going to cost is uncertain. And our job is to help you manage that risk generally. Now, we have a lot of experience in dealing with litigation, and we can therefore give you, on the basis of that experience, an idea of how long it may take, how much it may cost, and what the outcome may be. But we can only provide partial answers to those questions because of the uncertainties. And that's why, and I'm going to speak like a lawyer now, that's why we express our advice to you in a very careful way. So my advice to you is to listen very carefully to what it is that we are saying, because we can't give you cast iron guarantees about what's going to happen. So what you need to do when it comes to litigation is you need to consider your options very carefully, and we will try and help you manage those. Questions like, is litigation the right thing for you to be undertaking? Do you have the financial resources and the time available to see this through? And are you willing to face the consequences of an adverse outcome? We are very happy to give you advice on those issues, and we'll then listen to what your preferences are as to how you want to go about things. Do you want to go all the way to a trial? Do you want to try and settle this amicably? Do you want to be aggressive or not so aggressive? Or do you want to do nothing? Those are all possible options, and we will discuss those with you. We are not generally an aggressive team as lawyers. I think that can be a knee-jerk attitude when it comes to litigation, and it can be counterproductive. If you want us to be aggressive, then we're happy to do so, but it does have to be backed up by evidence. Otherwise, there's a danger that it will be seen through by the other side and you will lose credibility. It can also make things more expensive if you start making court applications left, right, and center. That can run up costs as a result. And it can result, even though you're in an adversarial situation with your opponents, if you take it too far, it can lead to a loss of trust, which can make it more difficult to settle a dispute in the long term. And with those general considerations out of the way, I'll pass you over now to Nichola, who's going to talk about timelines.
Thank you, Robin. No, I think you make some very interesting points there. And just to provide some context to the points Robin has made, I'll start with the timeline to begin with. As Robin notes, it can be very time-consuming litigation and drain on resources. And, management, are diverted away from running their business when they are dealing with litigation. So as a broad rule, we would say to go all the way from pre-action correspondence to trial, you're looking at a minimum of 2 years. And that assumes the case is in the High Court, in the Commercial Court, or the Business and Property Courts. Now, that comes with a warning that, most claims do settle before trial, but it's very important to recognise that you could go all the way to trial. And even when you get your judgment at first instance, you could then be locked in rounds of appeal. Throughout that process, when we're managing the litigation, there's peaks and troughs in the level of work required. Some of the stages we take will require heavy input from the client, and some, as lawyers, we can get on ourselves with minimal input from you. So initially, I'll just give you a high-level overview of the steps taken in the courts of England and Wales. The rules for the court are quite prescriptive, and most cases typically follow this process. So the first stage will be pre-action correspondence. The parties are actively encouraged, before they go to court, to engage in pre-action correspondence. The purpose of this is so each party knows their case, they know the other side's case, and you can attempt to narrow the issues between the parties. Now, in some cases, we can resolve matters very early on and at a pre-action stage. However, that's not always possible. If that's not possible at that point, we will issue a claim at court. And the first stage here is the pleading stage. And that's essentially where each party produces a formal document which sets out their legal case. Following this, once each party set out their case, we'll have the case management conference. This is the first time the parties get together before the court. Here the parties set out the key issues for trial, the scope of their disclosure, how costs will be managed throughout the litigation, and most importantly, the timetable that will follow through to the actual trial date. Once the case management conference has been concluded, the next stage will be disclosure. This is where the parties exchange documents which are relevant to the issues in the case. And this will also include documents which adversely affect your case. We then have witness statements where key individuals from either side will set out the factual position on the case. We then may have expert evidence if a matter requires it. For example, we could have accountants involved to provide an expert opinion on the valuation of a business, for example. We would then have the pre-trial review, which is a short hearing to check the matter is actually ready for trial, and then we'll have the trial. Once the trial is concluded, there will usually be a short pause where we await judgment from the court. And so that's the typical process. And then, as mentioned earlier, after that, there could be various rounds of appeal.
That's really clear, Nichola. Thank you very much. I'll just add one point that although that is the basic outline of the different stages, it's always possible for either yourselves or for your opponents to extend the time of this timeline and add further costs by making applications to the court in relation to every single one of those specific stages. So if they disagree about, for example, disclosure, they could make an application to the court asking for disclosure as specific documents. There's all sorts of ways in which the other side can make things much more complicated and long lasting.
Yeah, thank you, Robin, for clarifying that. And I think another point to actually mention, which will lead onto the next section I'm about to discuss, is, at some points in the process, the parties sometimes agree to a stay of the proceedings, and they may agree that stay predominantly for trying to engage in settlement negotiations to see if they can resolve the dispute. And I think it's important now when I go on to discuss settlement strategies and the timing of these to mention that there's increasingly an emphasis from the court on alternative dispute resolution. And from October 2024, it's as good as mandatory for the parties. And that manifests in several ways in the court rules. So the overriding objective now specifically provides that the objective of dealing with the case justly and at proportionate costs includes promoting or using alternative dispute resolution. The court's case management powers have been amended to include reference to the court powers to order alternative dispute resolution. And when giving directions throughout the case, the court must consider whether to order or encourage the parties to engage in alternative dispute resolution. Now, it's really important that the parties pay attention to the ability to engage in ADR, because whether a party has failed to comply with an order for alternative dispute resolution or whether it's unreasonably failed to engage in alternative dispute resolution can be taken into account when determining cost liability at the conclusion of the proceedings. So that's just something to bear in mind. The parties will expect the court to look at this, and you've really got to have a good reason as to why you didn't engage in alternative dispute resolution. Now, from our perspective, there are many good reasons why you might want to explore alternative dispute resolution and to try to settle the case. Firstly, there's the cost saving. Often the earlier in the litigation you can do this, the cheaper your outlay will be in terms of legal fees. It will reduce the burden of litigation on management time. As previously highlighted in this podcast, the court process is quite prescriptive, particularly when we're doing disclosure and witness statements. A lot of management time will be required to assist us. So if you can settle earlier or before that point, you'll massively reduce the burden on management time. Some reasons can be relationship preservation. Although parties are in a dispute, it's entirely possible that they may want to work together in the future. So looking at alternative dispute resolution can preserve that relationship whilst resolving the dispute. And there can also be publicity reasons to why a party may want to settle. Once proceedings are in the courts in England and Wales, they're a matter of public record. The court file can be accessed by anyone. And the case itself can be picked up by the media or other parties and attract publicity, which those engaged in litigation may wish to avoid. If you settle at a very early stage, and certainly at pre-action correspondence, that risk is removed. There's a lot of considerations about what is the most likely time for settlement. And the truth is, settlement can happen at any point in the case. It can happen very early on. It can happen at the court doors. It can happen even in between the point of the trial concluding and judgment being handed down. And really, when is the best time to settle is a decision we will have to make as the case progresses. I mean, for many reasons, as early as possible is optimal from a cost-saving perspective, but we may conclude that it's actually better to wait until the parties have engaged in disclosure. When we come to looking at ways of engaging in alternative dispute resolution, there are many ways we engage in this process. These can be formal or informal, but the most important thing to remember is that settlement continues unless there's been a stay for it. Settlement continues to run in parallel with the litigation. Now, I won't go in the course of this podcast into every step of a means of settlement, but just to highlight a few. So the main thing parties often do to try and settle is to arrange a mediation. And a mediation is where the underlying parties and their lawyers all convene on a particular day, and we get a mediator along who goes back and forth between the parties to try and narrow the issues and narrow the gap and pull out a settlement between the parties. Another way we can engage in settlement is through correspondence, and that can be via a well-pitched Part 36 offer very early in proceedings. I won't go into the technical details of a Part 36 offer, but a Part 36 offer essentially applies a cost pressure to the settlement and has cost consequences depending on the nature of the offer, which can play out if a party fails at the conclusion of the trial to do better than the offer that was made to them during the proceedings. And then there's also just general without prejudice discussions that can happen. We don't need a formal mediation between the parties to have settlement discussions. The lawyers can pick up the phone between themselves and have discussions at any stage of the proceedings. And sometimes we've even found it effective when the principals of the respective parties involved in litigations have a conversation together. And that can often, we find, cut through the matter, remove the legal jargon, and the parties look to decide what is a commercial outcome between themselves.
Thanks very much, Nichola. That's really helpful outline on the different settlement strategies which are available. I just wanted to emphasize one point that you mentioned earlier about the court's new powers to order alternative dispute resolution. I know there are cost consequences if people unreasonably refuse, but I think it remains to be seen whether or not if this will actually have a material effect in increasing the level of settlements. I mean, from our experience, if parties are forced to go to mediation prematurely, then there's a high chance that they won't actually succeed unless both sides have sufficient goodwill to agree to compromise. So that's going to be an interesting question to see how effective that is in the future. The second point is just to mention about the fact that most cases, as you mentioned, do settle. The overwhelming reason for that is the level of costs of going to trial and the fear of adverse costs orders if you lose at the end of a trial. That's good news about most cases, that they do actually settle. The less good news is that you can't actually assume when you're in litigation that the other side will settle. So you need to be prepared to go all the way, even if you are keen on settling yourselves. You need to be prepared for that possibility that you will need to go all the way to trial. So I hope you've found that helpful. If you have any questions, please do feel free to contact me, Robin Henry, or Nichola Leach at Collier Bristow. Thank you very much. Goodbye.